May I seek a small clarification in respect of today, up to what time in the morning section does the court intend to sit? In other words, when do we break for lunch? When do we come back? If we break for lunch at all, we are in your lordship's hands.
I think it would be prudent for us to break at 1 and come back at 2.
Thank you.
Yes. Senior Counsel Paul Muite, we would like to know how many will be addressing us so that we allocate time.
For the 8 counsel appearing for the petitioner, the first petitioner, my lords, your ladyship, bearing in mind that the first petitioner is the subject of the impeachment, the main pleader in these proceedings, we have divided the highlighting of the submissions amongst the 8 of us. Perhaps my learned friend, Senior Counsel Gachagua and myself will take a little longer than the others. But the plea I'm making with what I'm saying is to plead with the court to bear in mind that this is the first opportunity. The petitioner, first petitioner, is having for stating his case. I plead that he be given adequate time. Thank you.
So what are you proposing?
I am proposing, in other words, my lords, that you kindly allocate me 1 hour give or take, and Elisha Ngoya 2 hours give or take, and the others 30 minutes give or take. That will be adequate for us. In fact, this honorable court had indicated when we last appeared before the court that we would have today for the petitioner's case. And because there are many petitioners, I was just saying the person most affected is the first.
My lord and my lady, on our part, the third petitioner would request to be given 1 hour.
If it may please the court, Mwanannchi for the petitioner will just take 20 minutes to the explanation.
Lordships, between myself and my brother Sakimpa, will equally need 1 hour.
Bear in mind that the day has its own
We endeavor to make it shorter.
All right. I think we will proceed on the basis that we'll give you as much time as humanly possible to begin a day.
We agree. Hello? May I start, Your Honor?
Yes.
My lords, your ladyship, the court will recollect that when we last appeared before this noble court on the 24th of February 2025, I stated to this honorable court on record, on behalf of His Excellency regarding Gachagua, that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency regarding Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish again, my lords, your leadership, to reiterate that position on record. My lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the question, if this court agrees with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law, plus damages. Finally, for the period of 2.5 years that His Excellency regarding Gachagua served as the second Deputy President of the Republic of Kenya, it is our submission that Article 151 of the Constitution is fully applicable, and I invite your Lordship and your leadership to have a look at that Article 151 when you retire. Briefly, my lord, impeachment cannot and could not have been retrospective. That is the submission. My lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his further amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October 2024. Number two, his bundle of authorities and case digest, dated 7th of October 2025. And number three, the first petitioner's written submissions, dated 7th October 2025, which submissions are the ones we are highlighting today before this local court. Now, paragraph 1 to 19 my colleague is drawing my attention that we also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April 2026. Thank you. My lords, your leadership, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this honorable court when it retires to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this honorable court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the allegations made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you will find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go, that the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this Honorable Court to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. Lord, if you look at paragraph 8, 9, and 10 and 11, and they appear from page 8 of our written submission. Paragraph 8, my Lord, you see, the respondent, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider, and I pause here to emphasize the word plenary, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution and the standing order, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President, the first petitioner, the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced a schedule on 16th of October 2024, when the Honorable Muite's evidence was fully discredited in cross-examination, and this Honorable Court will be taken through all that. My learned friends here. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President, not the National Assembly. Lord, all this and many more is evidence of clear bias on the part of the National Assembly, despite, on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But On the second day, and I'm looking at paragraph 10, when the deputy president was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the deputy president on 5 out of the 11 counts. And you find all that in RG 11, volume 9, pages 1689 to 1725, response by Brigadier Gachagua. And also RG 12, volume 9, pages 1752 to 1758, communication from Nigeria. My Lord, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly and the Senate to address their minds to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems of government. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the prime minister. There are many examples of parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution that members of the National Assembly can vote and christen their resolution that they are breaches of the Constitution, and you will be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. In other words, what I am highlighting here is what the court says in the song called Moving Gideon Kioko and another versus Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I say, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. My Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the Deputy President to be addressed by each one of us. My Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different councils. My Lord, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2020 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations, whether that was unconstitutional. My Lords, Your Leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, the notice of motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional order. My Lord, Your Leadership, my learned friend Dave Wanjiru here, and myself had the privilege of arguing the Wambora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution, or other reasons. No, they didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wambora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against a governor, in this case deputy governor, may I say, not just the deputy governor, the law that this honorable court will be laid down or reiterate will apply to the impeachment of the president himself. It's very weighty issue that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as the Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law warranting his removal from office by impeaching the Deputy President on the basis of a section that had been nullified by this court. What Sigino was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. And my Lord, you find that authority, paragraph 62, allied case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Leadership, the Senate voted on that impeachment charge on the basis of a repealed section. And you'll find that in Exhibit RG3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security agent. My Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, sub-article 5, is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is 206 of the laws of Kenya. You will find in Part 3, Civilian Authorities, the heading, Effective Civilians Authority. They then say that the Cabinet Secretary will be the civilian authority oversight. The Cabinet Secretary is part of the executive. That is not civilian oversight. Simply put, this National Intelligence Act has never complied with the provisions of the Constitution. Had they operationalized that and set up a civilian oversight authority, it is that civilian oversight authority that would take up these issues. But criticism, despite the freedom of thought and expression in our Constitution, the first petitioner was still convicted for criticizing the NIS director. So, my Lord, Your Leadership, what you are submitting here is that there was absolutely no attempt by the National Assembly, by the Senate, to address their minds to the high standard of gross violation of the Constitution. My Lord, Ground 5 accused the Deputy President of grossly violating Article 3(1) and 148(5)(d) of the Constitution and of failing to uphold his oath of office and allegiance. There were no details provided. Instead, Ground 5 simply referenced Ground 1, 2, 3, and 4. This unfair and confusing charge was such that even though the Senate cleared the Deputy President of Ground 2 and 3, it still voted to impeach him based on Ground 5. There was no attempt to explain, even vaguely, how the Deputy President had violated his oath of office. Ground 6 equally alleged that there were serious reasons to believe that Rigathi Gachagua had committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why wasn't he taken first to the National Cohesion for prosecution before invoking the last resort remedy of impeachment? Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent, irrefutable, factual, and legal response to each of the 11 grounds cited in the impeachment motion. Lord, you see that in Exhibit RG2, Volume 2, pages 211 to 240. For instance, concerning the claim in Ground 8 that the Deputy President had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering, the Deputy President explained that no valuation had been done, so where the National Assembly, Honorable Mwengi Mutuse, got 5.2 billion is anybody's guess. If you want to charge somebody, you present evidence that this is the value of this property. Further, from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother, the late Honorable James Derito Gachagua. May his soul rest in eternal peace. Some, like the Olive Garden Hotel, Vipingo Beach Resort, Queensgate Serviced Apartment, he did not even own. And yet, this was what he was impeached on. But we are falsely attributed to him. He produced ownership document showing otherwise, and you will find that, my Lord, in RG2, Volume 2, pages 211 to 214. Lord, although the mover of the motion listed that the 2 companies associating them with the petitioner, first petitioner, alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption, and benefit from influence peddling, there was not a scintilla of evidence to support or prove those allegations. No evidence showed any impropriety, and you'll find that in RG2, Volume 2, pages 214 to 218. his or her deputy before the election so that the people could themselves vote is a very important aspect of our Constitution. The National Assembly trivialized the gross misconduct standard set out by the Constitution and other statutes for holding public servants to account. And, my Lord, I will not repeat the Wambora case, but I would state the impeachment motion was replete with generalized statements and supported allegations, hearsay, outright lies, lack of particularization and specificity as required by Article 145. My Lord, the exposition on all that is set out in paragraph 36 of our written submissions, and I will not take the time of this court going through them. I invite the court to read through it when you retire. Despite this glaring and fatal flaws apparent on the face of the motion, even on a cursory review, soon after the impeachment motion was tabled in the National Assembly, the first respondent issued a communication from the chair, number 46 of 2024, in which at paragraph 16, 18, and 20, he stated that he was satisfied that all the grounds in the impeachment motion met the requirements of the threshold under the Wambora case. The first respondent legally incorrect decision to allow the motion to proceed for debate, despite its clear failure to meet the specificity and accuracy requirements of the standing orders, seems to have been motivated by Parliament's biased and reckless haste to pass the motion as quickly as possible in order to shield the process and its obvious serious flaws from judicial review. It is our submission that that was the real reason for the rush. My Lords, Article 50, Sub-Article 2B of the Constitution states that every accused person has the right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer, to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that evidence. The motion thus violated Article 50, Sub-Article 2B and Article 50, Sub-Article 2J of the Constitution by setting out vague allegations, criminal conduct, including the Deputy President had violated repealed sections of the penal code, the leadership and integrity without ever charging him. Overall, the impeachment motion of the first respondent's communication from the chair was thus incapable of invoking the National Assembly's mandate under Article 150 as read with Article 145. My Lord, you will see all that in RG 1, Volume 1, pages 2 to 41, and RG 8, Volume 7, page 969 to 976. So, my Lord, that is all I wish to say about A. Let me very quickly move to C. My Lord, issue C there a problem with your gadget? Saying all of you're listening to the phones, not to the gadget. My Lord, issue C is whether the Senate.
Do I need to remind you about time?
Only another 10-15 minutes.
You have barely 5 minutes.
Yes. Yeah. Moving as quickly as I can. See, my Lord, which you find at page 40 of our submission, is whether the Senate misled by its misinterpretation of Article 145, rushed the process and denied the Deputy President hearing. The Senate, my Lord, recognizes the right to a fair hearing in considering a petition for removal of a person from office because they say so in their standing order number 81, the right to appear before the committee, the relevant committee. That is in standing order number 81. Whenever the Constitution or any other written law require the Senate to consider a petition or a proposal for the removal of a person from office, the person shall, and the word used in standing order number 81 is that the person shall be entitled to appear before the relevant committee of office. The petitioner here was denied that opportunity to appear before the committee. And the importance of the committee, my Lord, is that the committee has got less members. The law gives the subcommittee 10 days to investigate. And therefore, the Deputy President would have been able to appear before that subcommittee with his evidence, with his lawyers, and would have been able to argue his case. By bypassing the setting up of that committee and assuming that the 10 days related to the plenary, which they did not, the Deputy President was denied a fair trial. My Lord, when the Deputy President had all along appeared in person and signaled his willingness to take the stand, he became mute. And none of us, all of us are human beings. My Lord, illness does not come knocking. One is just taken ill. And he was taken ill after very stressful, strenuous proceedings, National Assembly, and the first day in the Senate. Lord, it's a very stressful situation for the Deputy President to be deprived of that position to which he had been elected by over 7 million people. Lord, when counsel for the Deputy President stated that he had been taken ill, the Speaker ruled of the Senate, I said we were going to execute with military precision owing to the fact that we need to conclude business today. And he said I had indicated that I could not get hold of the client. All the doctors advised, because he had been admitted to ICU. Lord, first, the 10 days did not apply to the Senate. That was a misreading of the Constitution and the law. But secondly, there was time we were requesting adjournment up to Tuesday to see about the Deputy President improvement. But the Speaker said they could only adjourn up to Saturday. His proposal for adjournment to Saturday was shut down by the senators voting and saying they would not allow adjournment even to the following. And no reasons were given for rejection of an adjournment to the following day, Saturday. Lord, this was a serious violation of the rules of natural justice. Lord, adjournment by the Senate is discretionary, but like all discretionary power, the discretion is to be exercised objectively, judiciously, and upon reason, not arbitrarily, capriciously, or on whims. Here, falling ill on the second day of a grueling two-day hearing, the Deputy President sought a 3-working-day adjournment to Tuesday, 22nd October, to enable him to recover and appear for cross-examination. The Senate defeated that proposal to adjourn until Saturday to see if the Deputy President had recovered. Egged on by the National Assembly, the Senate insisted on proceeding in the Deputy President's absence. My Lord, you will see at paragraph 83 of our written submission the case of the then Major General Peter Kariuki versus Attorney General. It is number 3. It is paragraph 3, page 250 in our banner, where the Court of Appeals said the appellant's request for a 3-working-day adjournment, 3 days adjournment, to instruct counsel was denied. He had been held incommunicado without access to a lawyer for over 147 days. He had less than 10 hours in total, and in a prison setting to instruct his lawyer to prepare his defense. Overturning the court-martial decision denying the adjournment, the Court of Appeal explained, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of application for adjournment of criminal trials, nevertheless, because of the constitutional basis of that right, the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for the adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. And there are very many cases cited, even in the common law. My Lord, again, I had the privilege of arguing this case before the court-martial back in 1983, following the attempted coup, and also through the High Court, through the Court of Appeal. The conviction by the court-martial was quashed on the basis that Major General Kariuki, the commander of the Air Force, had been denied a fair trial. My Lord, in the interest of time, I was going to highlight the speed with which the whole process from the word go all the way through was done, but including the rest of it. But I invite the court to read our written submission. I only mention that after hearing the Deputy President on the 8th of March, finishing at about 8 p.m. Anyway, on the date that the National Assembly considered this motion, they voted to impeach close to 9 p.m. The normal working hours are daylight hours. How is it that the National Assembly could not even wait for the following day to transmit their resolution to the Senate? Lord, it was transmitted at night. And the following day, the Senate set the date to commence the proceedings. Equally, when the Senate, after depriving the Deputy President a fair opportunity to defend himself, impeached on 5 out of the 11 grounds. Equally, they had to transmit the impeachment resolution back to the Senate close to midnight on the same night. My Lord, I'm inviting this court to see this breakneck speed. Somehow, the Speaker of the National Assembly had in advance issued a notice convening a sitting of the National Assembly. On a Friday, which is not a normal sitting day. Any thinking person will wonder how the Speaker of the National Assembly, a good friend of mine, senior counsel, how was he able to anticipate the likely decision of the Senate in advance? And above all, although the resolution of the Senate was being transmitted back to the National Assembly after midnight, between midnight and the following day, His Excellency the President had time during the night to get clearance for the person he wanted as his Deputy President from the Ethics and Anti-Corruption, from KRA, from the Electoral Commission. These are public institutions. In fact, the Electoral Commission did not even have commissioners to make a decision clearing the choice of the Deputy President. But I mention this to demonstrate the unholy rush. I invite this court to see through the smoke screen cotton thrown about by the National Assembly and the Senate to confuse issues. They were merely saying we have the numbers. There was no attempt to address serious violations of the Constitution. Lord, I hand over to you.